Welcome to this video, brought to you by the Truth and Action Share Club. We are focusing on Patti's challenge against the notion that prosecutors are above the law. The case, Patti versus the prosecutors, highlights a rule of law crisis. Two core complaints are presented. A clerk shut down a filed judicial review after acceptance, and the Attorney General argues prosecutors are not subject to judicial review. The core issue is whether state actors are operating above the law. The background involves Patti Wood engaging in a peaceful protest on Parliament Hill in a designated lawful area. Despite no violence or disorder being alleged, she was arrested, handcuffed, and placed in a police vehicle. This scene provides a visual summary of the background. Peaceful protest, no violence or disorder alleged, yet Patti was arrested, handcuffed, and placed in a police vehicle. Conditions during detention included an approximate temperature of 26 degrees Celsius in an enclosed vehicle with no air conditioning. Patti, who suffers from asthma, experienced an asthma attack, requested her inhaler, but the request was refused. The initial charge laid was trespassing. However, the charge was withdrawn, confirming she was not trespassing. Despite this, there has been no hearing, investigation, or accountability for her treatment. Following the events, complaints were filed, reporting channels were used, and requests for investigation were made. The result was a failed complaint process, with no authority agreeing to proceed and no forum for accountability. Canadian law permits private prosecutions when authorities refuse to act. Patti invoked this lawful mechanism, bringing the matter before a court to attempt to trigger judicial oversight. The Crown intervened under Criminal Code S.579, and proceedings were stayed. This occurred before evidence was heard, with no evidentiary process and no explanation in open court, stopping the process before scrutiny. An Ontario Superior Court judge ruled that the motion to proceed was not proper, stating the correct mechanism was judicial review. The judge clarified that the case would only be a review of the Crown's decision, not a criminal hearing, defining the issue as the lawfulness of the decision. Following the court's direction, a judicial review was prepared, filed, and accepted by the court, with a file number issued and served on the Attorney General. The case was properly before the court. Complaint number 1 involves the clerk shutting down the case after acceptance. The clerk rejected the application, marked the file inactive, and no further filings were allowed, resulting in an administrative shutdown after court acceptance. The legal issue revolves around clerk authority. Under Ontario's Rules of Civil Procedure, only a judge may dismiss or terminate proceedings. A clerk cannot strike a case, override judicial direction, or block access to the court. The proper process is to refer the matter to a judge. This sequence shows a direct conflict with judicial authority. The judge directed judicial review, the filing was accepted and a file number issued, yet the clerk stopped the proceeding. This constitutes administrative action overriding judicial authority. Complaint number 2 details the Attorney General of Ontario filing a motion under Rule 2.1.01. The position advanced is that prosecutorial decisions are not subject to judicial review. The Attorney General's position is an assertion of absolute power for the Crown, claiming that decisions on the administration of justice cannot be subject to judicial review. The Supreme Court of Canada confirms that prosecutorial discretion is broad but not absolute, as established in cases like Krieger v. Law Society of Alberta and R v. Nixon. The Supreme Court has indicated that review is permitted in cases of bad faith, improper purpose, or abuse of process. This confirms that legal oversight exists and is recognized for prosecutorial decisions. The 2024 case of AG v. Power reaffirmed the core principle that Parliament is supreme. Consequently, all state authority flows from law, all actors are bound by law, and no actor is above scrutiny. Accepting the positions of the clerk and the Attorney General would create a systemic risk of administrative control. Clerks could control court access, prosecutors could make unreviewable decisions, and judges could be bypassed. This shifts the system from law to administration. This potential outcome poses a real danger to the rule of law. It could lead to judicial directions being ignored, filed cases being stopped without orders, and Crown decisions becoming immune from challenge. This ultimately results in the collapse of judicial oversight. The full sequence shows a citizen seeking accountability, their case being stopped, a judge directing judicial review, the review being accepted, and then a clerk shutting it down, followed by the AG claiming no review is available. The system is blocking the lawful process. The final scene emphasizes the importance of challenging these actions to uphold the rule of law. Join us in supporting this cause for justice and accountability.